sentence of a life without parole. Count 2, alleges gross sexual position alleged on about the same time period as county that you did have sexual contact with him who was less than 13 years of age. That is a third-degree felony carries a possible prison term between 1 and 5 years, and both require lifetime designation as a registered sex offender. You're entitled to have an attorney represent you, and if you do not have a fund to hire one, I won't be appointed for you. I see you have to fill out a form. Is everything on this financial disclosure form correct? Everything on this form correct?
Should be.
Alright. Next portion will find that you are entitled to appointed counsel. 4 appoints attorney Catherine Hills for Ohio to represent you. And the letter not guilty put in your behalf. Bond review will be set for Monday morning, the 9th at 9 a.m. by Zoom. First pre-trial will be set for May the 18th at 1 p.m. That'll be by Zoom. Pre-trial will be June the 1st at 1 p.m. by Zoom. Trial date will be June the 27th at 8 a.m. in person. Bond will be set at $100,000 plus your own cognizance of your promise to appear. And if you fail to appear, then you make bond. You can be prosecuted for additional felony and convicted. Sentence on that will happen in this case. You'll also be required to pay a service fee of $171 for statutorily required fees. Will be required to report to the probation department if you make bond immediately, and then once a week to 4 weeks after that, as they determine. They go random drug testing, provide current phone number for home son employer, they go contact the alleged victim. Recommended by probation, be evaluated for substance abuse, mental health issues, and treatment indicated you're enrolled in the bottle letter and dependency of this action. You also be under house arrest for residence, meaning you have to be at all times while you're working. Point to and from work, medical appointment, court proceedings, and this or any other case. Appointment to an attorney probation officer, this or any other case. Have any questions, Mr. Clerk?
No, sir.
All right, we'll notify your attorney. Thank you. All right, are you Devontae Ames?
Yes, sir.
All right, this is case number 22 CR 120, State of Ohio versus Devontae Ames. You have been charged with 2 counts of drug offenses, Mr. Ames. The first one is aggravated trafficking of methamphetamine in the city of school zone. And it alleges on or about September 6th of last year, you and Sarah Workman did not only sell or offer to sell methamphetamine as a controlled substance in an amount equal to or exceeding bulk amount less than 5 times bulk amount, and that was done in the vicinity of the juvenile. That is a second-degree felony which carries a mandatory prison term of at least 2 and up to 8 years as or by the judge, with a possible maximum of up to half of that sentence being added by the Department of Rehabilitation and Correction. There's also a fine of $15,000 available, a mandatory fine of $7,500, and a possible license ban for 6 months to 5 years. Count 2 alleges on about September 6, 2021, you possessed that same amount. That is a third-degree felony which carries a possible prison term between 9 and 36 months, fine of $10,000, and a license suspension of 6 months to 5 years as possible. All right, you are entitled to have an attorney represent you in this matter. We'll hire one for you, and so you have to fill out the form, financial disclosure forms, everything on this form, correct? Is everything on this form correct? Did you fill out the financial disclosure form? Okay. Says you're unemployed. When's the last time you were employed?
Probably around 8 months ago. I've been treated for the past 6 months.
You been where?
I've been in treatment for the past 6 months.
Okay. All right. The court then will find that you are entitled to appoint counsel, appoint attorney William Armstrong, Hillsborough, to represent you. And in the absence of counsel, I'll enter a non-guilty plea on your behalf. Set your bond review hearing for May the 9th at 9 a.m. First pre-trial will be June the 1st at 1 o'clock by Zoom. Final pre-trial will be June the 22nd at 1 o'clock by Zoom. Trial will be set for July 11th at 8 a.m. That will be in person. Bond will be set to amount of $10,000 for pleasure on your cognizance, which is your promise to appear. If you fail to appear, then you could be prosecuted for additional felony. And if convicted, sentenced on that regardless of what happens in this case, you're required to pay a deposit of $171 prior to release to cover certain statutorily required fees. If you make bond, you'll be under pretrial supervision of probation department at 117 Main Street. Report them immediately after court. And once a week, 4 weeks after that, as they determine, we go random drug testing that they order, provide phone numbers for home cell employer. I have no contact with co-defendant. If recommended by the patient, be evaluated for some abuse of mental health issues, and trips indicated to roll in and file letter and penalty in the action. And you'll also be under house arrest. And you have to be the residence all the time unless you're working or doing from work. Medical appointments, court proceedings in this or any other case. Appointment from attorney probation officer in this or any other case. Other than that, you have to be there all the time. Fail to comply with any of these conditions, then the court will revoke that bond and have the help of further order. Do you have any questions, Mr. Haynes?
Yes. Right now, I'm still currently in treatment down there in Chillicothe, and I was curious about that, how that would work for, I don't know, I'm still in a program, I'm still under the supervision of John Paul, I'm still doing everything I need to do to take care of that stuff at the time being. I was just wondering if I could possibly just sit back in treatment where I was at. I turned myself in here yesterday.
We'll review that Monday after your attorney is able to talk to you, and we'll discuss it then. Right now, you'll have to pay a total bond. If you do make bond, you'll need to go back to treatment.
Yeah, okay, that's all I wanted to know.
Right. If you make bond, condition of your bond is that you are to return to treatment and stay in your treatment program until you're complete. All right.
Yeah.
Okay. Thank you.
That's all I got today.
Okay. So, let me call that. All right, this case number 21 CR 51, State of Ohio versus Sarah Faye Dixon. Are you Sarah Faye Dixon, attorney there from jail? All right, this hearing is being conducted by Zoom. This Dixon's attorney is Captain Hammer, attorney from her office, attorney from the prosecutor's office is Assistant Prosecutor King. The defendant entered pleaded guilty, aggravated possession of methamphetamine, if you're calling on June 30th of last year, placed in an intervention and restriction program. There was a motion filed to terminate the IL intervention restriction on March 2nd, and there was a hearing date set, and that did appear to have a case issue, and she was taken into custody, and I believe, over that, and this is an evidentiary hearing. All right, now Ms. Hammer, again, I'm going to review the allegations in the March 2nd motion with your client. All right. All right. Ms. Dixon, the charge for which you entered pleaded guilty to was a 53 felony, was carried responsible for prison term between 6 to 12 months, fine of $25, and a license suspension of up to 5 years. You're entitled to have a hearing on these allegations, in which the state is required to present evidence and proofs to the court that you have committed these violations. You have a right to have your attorney cross-examine those witnesses, try to bring out evidence. I'm sure that the case you have a right to present evidence on your behalf, but you're not required to. If you do not, it will not be held against you. The allegations that were filed are that you violated Rule 1, and that you pled guilty to driving under the influence of alcohol or drugs on November 18, 2021 in Louisville, Court, on December 22nd, 2021. Cited for driving under suspension of legal retreat, terrible, and support failed here. Also failed here. In the Louisville Municipal Court on February 28th, court review hearing. Rule 3, that when you staff it, so think about mental health, you've had no contact with them since December of last year, and only completed 14 of 36 appointments since June of 2021. Rule 4, you have a report since December 30, 2021, is not responding to voicemails or letters. Rule 9 is you fail to notify a supervising officer you're being arrested, charged with driving under suspension by B3 Police Department. Rule 11, that you tested positive for methamphetamine and amphetamines on November 18, and positive for the same thing again on July 26 of last year, which is why you're in custody for the OBI. And finally, Rule 14, you failed to make any payments under your court costs and fines other than one-third compensation commission. So those are the allegations. Now, you understand those allegations, Ms. Dixon?
Yes, sir.
We understand your rights to have a hearing. We understand that if you admit these, then the court will terminate you from the ILC program, find you guilty, and then we'll have a sentencing hearing at a later date. You understand that? Okay. You admit then the violations?
Yes, sir.
All right, the court then terminates the defendant from the intervention and the conviction program, orders and finds defendant guilty of the offense of aggravated possession of methamphetamine, 53 felony. Court will order updated pre-sentence investigation report. And that will be set for sentencing. June 1st at at 9 a.m. That's a Wednesday. Is that a day you're in the courthouse messed up?
Actually, not that.
All right, 9 a.m. All right, bond will be complete. And court will also order assessment for SUD and mental health issues. All right, thank you. All right, Rachel Skeens, is she in the jail?
Rimskins?
Yeah.
I believe so, Judge.
I'm sorry, I said Rachel. Ms. Hammer, I pointed you to Mr. McClure this morning.
Yeah.
Now, you were in the lower court, so you can blame whoever pointed you up there.
Yeah.
Yeah.
I think that was a good practice.
Yeah.
Hey, is, Mr. Hughes will be on the board?
No,
Okay.
not surprised.
Well, I talked to him yesterday, so I, was hoping he actually show up.
What time is he supposed to be here? 9? Oh, yeah. No, he's not. All right, are you Red Michael Skeens? All right, this is case number 22 CR 96. State of Ohio versus Red Michael Skeens. Mr. Skeens is appearing by Zoom from the jail. Attorney Catherine Hacker is appearing from her office. Attorney on behalf of the state prosecutor's office, Assistant Prosecutor King. This matter is set for a plea of guilty. Then charged with 4 counts, and we'll look at our trial date. I think it's sometime not so good. All right. Now, Ms. Hafner, you and your client both stipulated this hearing be conducted by Zoom, waiving any personal appearance in the courtroom. You're in agreement with that, Mr. Skeens?
Yes, sir.
All right, thanks. All right, now, I have been presented with a plea of guilty form, Mr. Skeens, which is a 3-page document. Actually, this one's 4 pages. That's prepared by the prosecutor's office on forms they have in their computer. And it says education number and name and plea of guilty. I'll hold that up to the camera on my computer so you can look at that and you can recognize that agreement as the agreement we're talking about here that you're going to plead guilty to. Okay, I'm sorry, here, how about that? Hold on, okay. All right, has your name, case number, and says plea of guilty. Okay? All right. On page 3, there are signature lines, and down at the bottom, there's a sentence that reads, I enter this plea voluntarily, and right below that is a signature of defendant. So I'll pull that up there. Can you see that there next to my finger? All right, is that your signature? When did you sign this agreement, Mr. Skeens? All right, and your attorney was there with you when you signed it? Did she go over with you and explain everything to you and answer any questions you had before you signed it? Did you understand when you signed it that it was an agreement to plead guilty, which means that there won't be a trial and the next step in your case would be a sentencing hearing? All right. Now, the agreement states, let me back up. You feel you have enough time to fully consider this matter before making the decision to sign this agreement? And did you enter into the agreement and sign it voluntarily? All right, now the agreement states on page 1, you're going to withdraw your plea to count on not guilty to change it to guilty. And that is aggravated trafficking methamphetamine. Currently charged with 2 counts of that and 2 counts of aggravated possession, all second-degree felonies. Now, the agreement further states that you understand that the possible maximum prison term for this offense is 8 years as set by the judge. Now, the judge has the authority to set, to imprison somebody for this offense to a term of anywhere between 2 and 8 years. And that is a minimum. Now, in this case, that's a mandatory sentence. There can be no community control or probation. There can be no early release, judicial release of any sort. The only credit you get is for time served. And under the law, since this is a second-degree felony, the Reagan-Coates law provides that if the DRC, Department of Rehabilitation Corrections, looks at your case and decides that you should be held longer because of certain risks they determine, then they could extend that by up to 1/2. So, if your minimum sentence was opposed to 2 years, then they could hold you for up to 3. If the minimum, if the sentence that was opposed to the minimum was the maximum 8 years, then it could be up to 12 years, as determined by DRC. There's also a fine of $15,000, a possible license, or a mandatory fine of $7,500, and a possible license suspension of 6 months to 5 years. You understand all that? Now, are you currently facing any felony charges in any other jurisdiction? Where's that? And is that charge pending, or have you been adjudicated? What's the situation there? Alright. It is felony? Okay. Well, if you should be convicted in this county and sentenced to prison, and convicted in Fayette County, sentenced to prison, that sentence could be ordered to be served consecutively to the sentence in this case, which means a possibility of back to your prison term. You understand that? Are you currently on probation, community control, parole, or post-release control for a felony from any jurisdiction? Alright? Now, as I explained earlier, under the law, the possible the sentence that's being imposed is mandatory by the judge in 2 and 8 years to be extended by up to 50% or 1/2 by the DRC. Once you complete prison term, whatever it may be, whether it's what the judge ordered or if it's more, as determined by DRC, it is required under Ohio law that you be put under post-release control supervision of a term set by the adult parole authority for a period of at least 18 months, up to a maximum of 3 years. And that would be up to the discretion of the parole board. The court's not involved in that decision. And if you commit any violations of any conditions that they propose while you're under the post-release control supervision, they have a right to return you to prison, making you serve an additional period of up to 9 months for any one violation, up to a maximum of half of your prison term for all violations. But if you commit a new felony, then an additional whatever sentence the judge in the new case imposed on you, the judge would also sentence in this case, or sentence you for committing that offense while under post-release control supervision in this case, to an additional period of 1 year, whatever time is left on the post-release control period, whichever is greater. If that occurred, that would have to be served consecutively the sentence in the case. Do you understand that? Now, as I explained earlier, this is a mandatory prison sentence, so there's no possibility of community control or probation. You understand? Now, the first county indictment alleged is on or about June 2nd, 2021 in this county. He did knowingly sell or offer to sell methamphetamine, a Schedule 2 controlled substance, amount equal to or exceeding 5 times involved, less than 50 times involved. In violation of section 29.5.03A1 of the Ohio Vice Code. So, that is the charge of aggravated trafficking methamphetamine. Now, you understand what it is you've been charged with the state said you did, when, where, and how they alleged you did. And if you discuss the nature of the charge, the evidence in the case, possible legal issues in the case, possible defenses might try to raise a trial, possible outcomes of a trial with your attorney. Are you satisfied with your advice and confidence in this matter? Are you under the influence of any type of drugs or alcohol at this time? Have any threats been made to issue plead guilty here today? Now, on page 2 of the agreement, there are little over 3 lines printed in bold print and underlined, so I will read those. Defendant shall enter plea of guilty to count 1. State will dismiss the remaining counts. State defendant's joint recommend 4 years mandatory incarceration. Defendant shall pay restitution amount of $725 to the task force. Defendant shall cooperate fully with the task force. Is that your understanding of the agreement? Anyone promise anything other than that case you plead guilty? Under the law, the matter of sentence is up to the judge, not the parties, Mr. Skeens. So even though there's recommendation from both sides that the sentence should be 4 years mandatory, if you plead guilty, I could impose any sentence between the 2 and 8 years mandatory that I think appropriate. You understand that? Now, do you hold any license or certificate from any state governmental agency that regulates any occupation or profession? Right now, we have certain constitutional rights to understand for it and accept the guilty plea from you, Mr. Skeens. First, you have a right to a jury trial in this matter, in which 12 people would be selected from a group of citizens who live in Hyden County. Summons for jury duty on your trial day. After they are selected, the evidence will be presented, and then they would be instructed on the law, and that jury then would have to find by unanimous verdict what the state free to go. Now, if you just unanimous means all 12 have to agree. Now, if you did not want to have a jury trial, but you did not want to plead guilty, you waive, which means give up in writing, right to have a jury trial. In that case, you have what's called a court or bench trial, which means that instead of the jury hearing the evidence would be the judge would hear the evidence, the judge would apply the law, and the judge would make the decision as to whether or not the state proves your guilt by proof beyond reasonable doubt. You understand that? Right, under the Constitution, you have a right to confront witnesses against you and cross-examine through your attorney. What that means is that witnesses against you have to come into court, testify in front of you, your attorney, and anyone else. After the prosecutor done asking questions, your attorney asks questions. That's called cross-examination. The purpose of that is to try to bring out evidence that helps your side of the case. You understand that? Under the Constitution, you have a right to use the power of the court. You compel, of course, witnesses to come into court to testify for you, just like the state. So, if you have witnesses you're not certain are going to come to court voluntarily, it's your request, the court issues a court order, called subpoena, and of course, those witnesses come to court to be able to testify if they want to, even though they don't want to be here, which is the same way the state witnesses are required to come to court. You understand that? All right, now, under the Constitution, you have a right to, or a privilege against self-incrimination. It means that you cannot be forced to give evidence in this matter at any time, including trial. No one can ever make a testify. The prosecutor can't, the judge can't, you make the decision. If you decide not to testify, the fact that you did not testify, not be used against you in any way, at any time, anyone in the proceedings. No one's even allowed to talk about it, except in one situation, that is, if there's a jury trial and you cannot testify, the judge instructs the jury that because that is your right, you cannot consider it. Understand that? Right now, under the Constitution, you're presumed innocent until proven guilty by the state of Ohio on every essential element of the defense charge. What that means is that the burden of proof is on you to try to show you're not guilty simply because you've been accused. In fact, under the law, you don't have to present any evidence in your own defense at all. And you may, but you're not required. Whether you do or not, the burden of proof will remain on the state of Ohio to prove your guilt, prove your own written doubt, which is the highest burden of proof is known under the law. You understand that? All right, now originally you entered a plea of not guilty. Not guilty plea denying allegations in the indictment denies committing a crime. That exercise from both all the rights that I've described for you. Now, if you change your plea from not guilty to guilty, that is the opposite of not guilty. Guilty plea admits allegations in the indictment, admits their crime, refused to commit that crime. That plea waives all of the rights that I've just described for you today, except for a right to have an attorney. You always have a right to have an attorney no matter what you plead. But that exception, your plea of guilty, waives up the right to have a jury trial, waives up the right to confront witnesses against you cross-examine for your attorney, waives up your right to use the power of the court to compel, of course, the Supreme Court to testify for you, the same as the state, waives or gives up your privilege of self-incrimination because you're saying you're guilty, doesn't find you guilty, waives up your presumption of innocence because if you say you're guilty, the state doesn't have to prove it. Subject you being sentenced immediately by the court, which is what's proposed here, and is likely to happen. And finally, it waives up any right to file an appeal that you think you may have had up to this point in the case. Now, if you should be sentenced to the maximum sentence, under certain circumstances, it could be a right to appeal, that would have to be filed within 30 days of your sentencing to be filed. You understand all that? And are you a U.S. citizen, Mr. King? All right, now, do you have any questions about the charge or the possible penalties? You understand? Have any questions about the plea agreement? You understand? Again, you understand the court's not obligated to follow the sentencing recommendation. You have any questions about the constitutional rights of this plan? You understand those? You have any questions about the plea of guilty, what it means, what will happen at the end of that plea here today? You understand that? I did say this earlier, Mr. Sheen, that if you need to talk to your attorney about anything, I can push an attorney to a breakout room. So just the two of you are on the screen talking to each other, no one else will be able to see you here. So if you need to talk to her about anything before we go any further? You have any questions about anything I was explaining to you this morning? Then is it your decision, Mr. Sheen, to withdraw your not guilty plea, to plead guilty, according to the terms of this plea agreement and this comment? And as to the charge that alleges in count 1 that on or about June 2, 2021 in Hyman County, Ohio, you did knowingly sell or offer to sell methamphetamine, a Schedule 2 controlled substance in an amount equal to or exceeding 5 times bulk amount, less than 50 times bulk amount, violation of section 2925.03A1 of the Ohio Revised Code, a second-degree felony that carries a mandatory prison term of at least 2 years, up to 8 years, as set by the judge. Maximum term of up to 1/2 of whatever term imposed by the judge will be added on by the DRC. A fine of up to $15,000, mandatory fine of $500, and a possible license suspension of 6 months to 5 years. How do you plead? All right. Court finds on this day of the court, defendant provides all constitutional rights and no intelligent voluntary waiver the same pursuant to Rule 11. Please accept that order 5. Defendant is found guilty of the offense charge. Counts 2 to 4 are dismissed. The court will not order a pre-sentence investigation. Instead, proceed with sentencing forthwith since this is mandatory prison offense. Right. Anything from the state regarding sentencing? Is happening anything on behalf of the defendant?
If you're going to ask if you follow the agreement of the parties, that it is an appropriate sentence. Mr. Sheen still has to resolve his cases in Fayette County. We also ask that it is suspended delay of fine. Obviously, not in any position for earning the next few years and remains an indigent.
Right, Mr. Sheen, is there anything you'd like to say?
Yes, sir. I don't know how to word it. Anyways, good activity, because I was messing up there. I didn't take the time to get ready and just kept using drugs, you know. And this time, when I got out, I was like, I got out, and seeing how quickly the whole life came back, that started getting to me. So I felt the game, so it's really great lesson. I just had to recall the agreement now. I need to take steps I need to take to get better on it.
It's the judgment of the court then that you be and are hereby sentenced to a mandatory term of 4 years at the correctional center of Ohio. This would be a mandatory minimum sentence imposed by the judge with a maximum possible sentence of up to 6 years, being 2 years being possibly added on to the 4-year mandatory sentence. Now, upon completion of the prison term, it is mandatory that he be placed under post-release control supervision by the adult parole board for a minimum of 18 months, and it could be up to 3 years as they determine. That means that she'll be supervised on terms that they set for a period, whatever of that period. And if during that period of time, they determine that you have failed to comply, then they can return you to prison to make you serve the additional period of 9 months for one violation, up to half of your prison term for all violations. However, if you committed a felony, then in addition to whatever sentence the judge in the new case imposed upon you, that judge is also authorized to sentence you in this case to an additional period of 1 year, whatever time is left on that period of post-release control, whichever is greater, that's very limited for the sentence. It's also ordered that you pay the court costs for which doesn't grant execution order, and if you fail to do that, the court like that for various reasons, including limit bank account payments or any other assets you may have. If that doesn't collect it, then they can, upon completion of your prison term, not liable, but once you get out, you can be permitted to do community service in this county. You give credit for each hour you work in an hour rate set by the court. Each hour you work, you reduce your judgment by that amount until it's paid full. The court also orders you make restitution in the amount of $720 to the County Task Force, and that court will be paid to the County Victim restitution escrow account, paying fees associated with that. That is a restitution order that cannot be discharged in bankruptcy, so you have to pay it even after you serve all your term. Otherwise, you can be brought back to court and that can be enforced. Court will not impose any driving suspension or any fine. Court finds if you're unable to pay that mandatory fine, and the lines will be able to pay. All right. Is there anything further from counsel? Oh yes. For 25 days. You're arrested on the like 10th of April. Is that correct? Okay. All right. All right. You remain in touch then, Mr. Gaines. Are either of you Douglas Peterson? All right. We have a gentleman in the room that they're not Mr. Peterson, so I'll go ahead and call the case while you're on Zoom this happens. You don't have to come here. You're not scheduled to be over here this morning, are you, in person? All right. Okay.
Hold on just a second, folks. You find him here.
That always is over to you.
I believe so, yes.
Oh, okay. Oh, yeah, right. Okay. All right, case number 22 CR 65, State of Ohio versus Douglas E. Peterson. This hearing is set for Mr. Peterson to appear in person before the court on a motion to revoke bond filed by the state March the 8th. I'm sorry, when it's filed, he granted a water bond on March the 8th. The defendant is not present. Mr. King is appearing by Zoom of the prosecutor's office, and Ms. Hacker, the attorney, the defendant, is also on Zoom from her office from earlier areas. And so he has not appeared. Ms. Hacker made comments to talk to him yesterday, but we hadn't heard from him this morning.
I spoke to him yesterday. I don't know several times over the one call, but obviously I had yesterday, and my assistant will be answering this afternoon. We had been here this morning, and I did indicate that there was a possibility that the charge of no license to appear and did not appear. So while I had pressed upon him, the court is being here this morning.
Mr. Archie, in the courtroom, have you heard anything from him since his motion was filed? No, he's not been reporting. I was calling in, and then I saw him last court. Last time I saw him was last court. He's not since then. All right. Well, then the court will order a case issue for his arrest, and he's taken in custody. Then we'll bring the court back on the thing.
Thank you.
All right. Go ahead. Listen, I'll mute, and what's your name? Jerry. Stephanie Fleming. Hold on, mute. All right, here's Stephanie Fleming, is director of jail. All right, this case number 21-0162, State of Ohio versus Stephanie Fleming. Ms. Fleming has been indicted for aggravated trafficking, two counts of aggravated possession. Fleming was to appear for a hearing on February 22nd, or she was reported to jail February 22nd. After she failed to appear for that hearing on that date, she did not supplicate was issued. So the court will restore this to the active docket, and bond will be set the amount of $10,000 SOR, and we'll set this for a status conference. May 18th at 9 a.m. By Zoom. And let's see. Attorney's Catherine Hampton. So we'll notify this after that you are in custody. All right, thank you. Ms. Barber, right?
So he was here earlier, and he got here early, and then we told him it wasn't until 9:45, so now he's on his way back.
All right.
I saw everyone.
Maybe here.
Yes, he is, Your Honor.
All right. 4A Hatfield.
My brother, Your Honor.
Okay.
Go ahead and seat right there.
Case number 22-CR67, State of Ohio versus 4A Hatfield, Secretary of State, Prosecutor King, President J. Wagner. You are 4A Hatfield.
Yes.
Hatfield is charged along with Defendants Peterson and Joshua Rowland. And they count back total, looks like he is charged in counts 5 and 8, 2 counts of aggravated trafficking, 2 counts of aggravated possession. I was sentenced going for a final pre-trial Wednesday. I've been presented Mr. Hatfield with a plea of guilty form, which indicates you're going to withdraw your non-guilty plea to count 7. Plead guilty to that charge, which is aggravated trafficking methamphetamine. Under 292503A1, first degree felony. Now, this is a 3-page document on page 3. About halfway down, they sentence that reads, I enter this plea voluntarily. Right below that, there's a signature that appears to be 4A Hatfield. Is that your signature I'm looking at here?
Yes, sir.
When did you sign this document, sir?
Yes, sir.
Right, and were you with your attorney when you signed it?
Yes.
And did you go over with me and explain everything to you before you signed
Yes,
it?
sir.
Did you understand when you signed it that it was an agreement to plead guilty, which means it won't be a trial, and the next step in your case will be a sentencing hearing?
Yes, sir.
Do you feel that you had enough time to fully consider the matter before making the decision to sign the agreement?
Yes, sir.
Feel that you were pressured or rushed in any way into doing that?
Yes, sir.
And are you entering into the agreement to plead guilty voluntarily?
Yes, sir.
And this is what you still will do today.
Yes, sir.
Right now, the agreement states on page 1 that says you're going to plead guilty to count 7. And it states that you understand that the maximum prison term for that could be 36 months in prison. The range is 9 to 36 months. Starts out with 9 and then 12, and every 6 months up to 36 for the final sentence. There's a fine available of up to $10,000. There's a mandatory fine of $5,000. There's a possible license suspension of 6 months to 5 years. Now, in this case, this is not a mandatory prison offense. There's a presumption that there should be one imposed, which basically is the legislature's statement that they think that that's a pretty serious offense, but it's not required. You understand that?
Yes,
Are you facing any felony charges anywhere else? Are you currently on probation, free control, parole, or post control for a felony? Any felonies other than this case? All right, now, under the law, Mr. Hatfield, if you are convicted of this offense, and should you be sent to prison, then upon completion of that prison term, it is possible that the adult parole authority would exercise the option, put you under what's called post-release control supervision for a period of up to 2 years. They don't have to, but they can. And if they do, you'll be supervised on the terms that they set because the court is not involved with that. And if they determine during that period that you have failed to comply, they can return you to prison until you serve the entire term set by the court for an additional period of up to 9 months for any one violation, but there's a cap or limit, a cap of whatever prison term is imposed for all violations. However, if you commit a new felony while under post-release control supervision in this case, then in addition to whatever sentence can be imposed in the new case, that judge can also sentence you to an additional period for committing that violation while under post-release control in this case. 1 year or whatever time is left on that post-release control, whichever is greater, that occurs, that has to be served consecutively with the sentence in the new case. You understand that?
yes,
And keep your voice up. Now, this is not a mandatory prison offense, so I can't impose what's called community control, or what most people know to be probation. That means that instead of being sent to prison, you will be put under the supervision of a probation officer, the term set by the court, for a period of up to 5 years. Now, if during that period of time the probation department felt that you were not in compliance, they would file a written notice to the court. There would be a hearing. You would be entitled to have an attorney at that hearing. If the outcome of that hearing was that you failed to comply, then at that time the court would revoke community control and then sentence you to prison for an additional period of or 200 period of 36 months and fine $10,000. You understand that?
yes, sir.
All right, now count 7 alleges that on or about April 27, 2021 in this county, Douglas Peterson and you did knowingly sell or offer to sell methamphetamine, Schedule 2 controlled substance amount equal to or exceeding bulk amount, but less than 5 times bulk amount. Violation section 2925.03A1. So that's the charge of aggravated trafficking and methamphetamine, third-degree felony. You understand what it is you're charged with, what the state says you did, when, where, and how they alleged you did it?
Yes, sir.
And you understand possible penalties for that offense?
Yes, sir.
Now, you discussed the nature of that charge, the evidence in the case, possible legal issues in the case, possible defenses you might try to raise in trial, possible outcomes of a trial with your attorney.
Yes, sir.
And are you satisfied with the advice and confidence in this matter?
Yes, sir.
Are you under the influence of any types of drugs, alcohol, at this time?
Yes, sir.
Have any threats been made to make you plead guilty here today?
Yes, sir.
Now, on page 2, there's almost 5 full lines printed in bold and underlined that read as follows. Defendant shall enter plea of guilty to count 7. State will dismiss the remaining counts. State defense on direct control, substance abuse treatment. Defendant agrees fully to cooperate against all co-defendants, cooperate with the task force. Defendant agrees to repay by money to Hyde County Task Force the amount of $360, joint and separately with Douglas E. Peterson. That's your understanding of the agreement?
Yes, sir.
Has anyone promised you anything other than that to issue plead guilty here today?
Yes, sir.
Under the law, the matter of sentence is up to the judge, not parties. So, you know there's a recommendation from both sides that the sentence should be controlled or not prison. I don't have to file that recommendation. And once I've heard all the information that's submitted to me, if I decide that's not the correct sentence, I could sentence you to a prison term between 9 and 36 months, and the increment provided by law, and a fine you of $10,000 and suspended license. 6 months to 5 years. You understand that?
Yes, sir.
All right, now, do you hold any license or certification in the state governmental agency that regulates any occupation or profession?
I have a driver's license.
CDL?
Just a regular driver's license.
Sorry?
Just a regular driver's license.
Just
Okay,
not
so other than that, you don't have any license for like, technician of some sort, medical technician, nursing assistant, or anything like that. All right. You have certain constitutional rights to understand before you can, be allowed to plead guilty, Mr. Hatfield. First of all, you have a right to have counsel. Mr. Whiteman was appointed to represent you. That wasn't simply to work a case out, but to provide any defense that may be available to you under the law that you'd like him to provide. So, if you decide that you do not want to do this, that you want to defend against the case, then he will continue to represent you and defend you, including a trial, if that's what you want. You understand that?
Yes, sir.
And under the Constitution, you have the right to have a jury trial in this matter, in which 12 people will be selected from a group of citizens that are summoned for jury duty, that live in this county, that are summoned for jury duty under your trial date. Once they are selected, the evidence will be presented, then they will decide by an unanimous verdict, 12 have to agree, as to whether to say truth or guilt of the offense. Now, if you didn't want to have a jury trial, if you didn't want to plead guilty, you can waive in writing, which means to give up the right to have a jury trial, and in that case, you have to hold a court bench trial meeting, and it would be the judge would hear the evidence instead of the jury. The judge would be the one that would apply the law, and the judge would make a decision whether or not to say truth or guilt by proof beyond reason of that. You understand that?
Yes, sir.
Now, under the Constitution, Mr. Hatfield, you have a right to confront witnesses against you and to cross-examine them for your attorney in open court. What that means is that that the witnesses against you have to come into court and testify in front of you and your attorney and anyone else is present. After the prosecutor's done asking those witnesses questions, your attorney can ask them questions. That's called cross-examination. The purpose of that is to try to bring out evidence from those witnesses to help your side of the case. You understand that?
Yes, sir.
Now, under the Constitution, you have a right to use the power of the court to compel or force witnesses to come to court to be able to testify on your behalf in the same state. What that means is that witnesses against you, from the witnesses that you have, if you're not certain, will come in voluntarily at your request 4 days before or risk of subpoena. That forces those people to come to court to be able to testify for you if you want them to, even though they don't want to be here, which is the same way the state's witnesses are forced to come into court to testify against you. You understand that?
Yes, sir.
Right now, under the Constitution, you have privilege and self-incrimination. What that means is that you cannot report or give evidence in this matter at any time, including trial. No one can ever make a testify. Prosecutor can, the judge can. You make that decision. If you decide not to testify, the fact that you did not testify cannot be used against you in any way by any person. No one's even allowed to comment about it except in one situation. That is, if there is a jury trial, you do not testify. The judge instructs the jury that because that is your right, they cannot consider it for any purpose. You understand that?
Yes, sir.
Under the Constitution, Mr. Hatfield, you are presumed innocent on this charge until proven guilty in the state of Ohio on every essential element of the offense charge. What that means is the burden of proof is on you to try to prove you're not guilty. In fact, in the law, you don't have to present any evidence at all in your defense at trial. You may, but you're not required to. But whether you do or not, the burden of proof will remain on the state to prove your guilt on every essential element of the offense charge by proof beyond reasonable doubt, which is the highest burden of proof is known under the law. You understand that?
Yes, sir.
Originally, you entered the plea not guilty, Mr. Hatfield. That plea denied the allegation, denied that you committed any crime, and that exercise will invoke all the rights that I described for you this morning. If you change your plea from not guilty to guilty, that is the opposite of the not guilty plea. Guilty plea admits the allegations in the indictment, admits their crime, that you committed that crime. In that plea, waives gives up all the rights that I have just explained for you today, except your right to have an attorney. Because you always have a right to have an attorney no matter what you plea. With that exception, your plea of guilty waives gives up your right to a jury or a court trial. Waives gives up the right to confront witnesses against you in open court and cross-examine them through your attorney. It waives gives up your right to use the power of the court to compel force witnesses to come in court to testify for you, the same mistake. Waives gives up for privilege and self-incrimination, because if you say you're guilty, that's what you define guilty. And waives gives up for presumption of innocence, because if you say you're guilty, the state's not required to prove guilty. A plea of guilty also subjects you to be sentenced immediately by the court. And finally, if waives gives up any right to file an appeal, as you may have had up to this point in the case. Now, if you should be sentenced to the maximum sentence, right, under certain limited circumstances, an appeal could be filed. That appeal would have to be filed within 30 days of your sentencing entry to be filed. You understand all that?
Yes, sir.
And are you a U.S. citizen, Mr. Hatfield?
Yes, sir.
Now, do you have any questions about the charge or the possible penalty?
Yes, sir.
You understand?
Yes, sir.
Do you have any questions about the plea agreement?
Yes, sir.
You understand?
Yes, sir.
Do you have any questions about the constitutional rights that I've explained to you?
No, sir.
You understand those?
Yes, sir.
Do you have any questions about the plea of guilty, what it means, what will happen after that plea here today?
Yes, sir.
You understand that?
Yes, sir.
Is there anything that you would like to speak to your attorney about before we go any further?
No, sir.
Have any questions at all about anything that I've explained to you here this morning?
No, sir.
And it's your decision to withdraw your not guilty plea and plead guilty to the charge set forth in count 7 we just discussed in this plea agreement.
Yes, sir.
All right, and then as to the charge in count 7, it alleged Honor Valley, 27, 2021, Huntington County, Ohio, that you and W.C. Peterson and you were Hatfield did knowingly sell or offer to sell methamphetamine, a schedule 2 controlled substance, an amount equal to or exceeding bulk amount, less than 5 times bulk amount, in violation of section 2925.0381, Ohio Revised Code, the charge of aggravated trafficking of methamphetamine, a third-degree felony carrying possible prison term 9 and 36 months and provided by law, a fine of $10,000 and for a fine of $5,000 and a possible license suspension of 6 months to 5 years. How do you plead?
Yes, sir.
All right, thank you. Court finds on this day of the court, defendant liable to responsible right, may only cover on fair waiver, same percent 11. Please accept the court file defendant's found guilty of count 7. Charged therein. Counts 5, 6, and 8 are dismissed as the defendant. Court orders that a pre-sentence report be provided that shall include the substance disorder and or mental health issues. Sentencing will be on June 1st at 9 a.m. on the due team. You'll need to report down to the probation department as soon as you get down there this morning to see make an appointment for the pre-sentence. All right, is there anything further, counsel? All right, and we're going to be signing those from Baylor to get out there. Thank you. That's John Barber. Okay, two cases before the court on the same defendant. This is John Michael Barber, case 20 CR 169 and 21 CR 32. President of the state, Assistant Prosecutor King, representing the State Department, Court Officer Carr, and representing the defendant is Attorney Jacob Wagner, and you are John Michael Barber. All right, Mr. Barber was on the Westport docket placed that on June 5th last year. There was a notification filed with the court on Tuesday, 3rd, that alleges that you have violated Rule 2, and on or after 4/28/22, you failed to report to the probation department. Rule 7 on 4/52/22, you used fentanyl and methamphetamine and amphetamine. Rule 7, or Rule 11, that on or before 4/26, you failed to report contact law enforcement by the end of that business day. And Rule 18, that on or about 4/29/22, you failed to appear in drug court last Friday. Now, you're entitled to have a hearing in this matter, Mr. Barber, and today's hearing is simply to notify you of that. Well, in the event that it's found to fail to comply, the court can do one of three things, like keep control, the same conditions as previously stated, and the treatment needs to make therapeutic adjustments. I can continue additional conditions that I think are appropriate. I also could impose sanctions which could permanently be sent to prison, or I could impose jail sentence by permanent program. Now, you're entitled to have counsel, Mr. White, here because these several other cases happen. Get a chance to talk to him about.
No, if I may, sir, Mr. The court's one, I apologize. So, if you want to do my next plea, Mr. Barter wants to stick around, we can sit down and talk about it, and maybe come back on the record. The court has time to maybe resolve it today.
Okay. That'll be fine.
And if you want to take a break, John, maybe one more plea, I'll meet you in that conference room.
About 15 or 20 minutes.
I'll report back to the court.
All right.
Okay? All right, mate.
Okay, we'll recess.
Thank you, sir.
All right, Dustin Green.
It's actually Alan.
Alan Green, I'm sorry, Alan Green.
My correct, Your Honor.
Alan, right here, buddy.
Case number 22 CR 68, State of Ohio versus Alan R. Green. President of the state, assistant prosecutor Adam King. Defendant's attorney Jacob Wagner. You are Alan R. Green.
Yes.
Green is charged in a 6-count indictment with 3 counts of aggravated trafficking in methamphetamine, 2 of them in a school zone, and 3 counts of aggravated possession of methamphetamine. This was a continuation of pre-trial that was set for the Wednesday, and was continued for the day of counsel's request. Matter set for pre-trial on the 3rd of May. I have been provided with a plea of guilty form, which indicates that you're going to withdraw. You're not going to plead guilty to the charges in the indictment. Count 1 and count 5. Count 1 as charged is a second-degree felony, which carries a mandatory prison term between 2 and 8 years, and is ordered by the judge up to an additional 1/2 of whatever sentence the judge imposes to be required to be served by the Department of Corrections. The proposal is that be amended to a 3rd-degree felony, which I believe would be accomplished by eliminating the allegation that's in school. Is that correct?
That's correct, Your Honor.
Now, and then also count 5, which is aggravated trafficking, also 3rd-degree felony. Now, this agreement is 3 pages long, Mr. Green. On page 3, there are signature lines. About halfway down the page, there's a sentence that says, "I enter this plea voluntarily," and I see what appears to be signature of Alan Green. Is that your signature I'm looking at here?
Yes, sir.
And when did you sign this agreement?
Yesterday.
And did you go over that with your attorney before you signed it?
Yes, sir.
And did you understand that since there's a plea guilty, which means it won't be a trial, and next time your case will be a sentencing hearing?
Yes, sir.
All right, and if you had enough time to fully consider this matter before making this decision? Did you have enough time to consider that fully before you signed the agreement?
Yeah, I figured I might as well get it with.
Okay, do not rush or pressure in any way to do this.
Okay.
All right, did you enter into the agreement, sign it voluntarily?
Yes, sir.
And you're entering into the agreement to plead guilty today voluntarily?
Yes.
Now, the agreement states, as I said, that you're going to plead guilty to 2 3rd-degree felonies under both aggravated trafficking and methamphetamine, count 1 being amended to reduce it, under 2925.0381. Now, further states, you understand that each of these charges, there's a maximum possible prison term of 36 months. That's the maximum. The minimum is 9 months. It goes from 9, then 12, then to 18, and then every 6 months up to 36 months. And there's a fine available up to $10,000 and there's a mandatory fine of $5,000, and there's a lease count, and there's also a license suspension of 6 months to 5 years. You understand that?
Yes, sir.
Now, also, there's a presumption that a prison should be imposed in cases like this. It's not required, but that is a presumption that's set forth by the legislature. You understand that?
Yes, sir.
Now, in the event you're convicted of both of these offenses and sentenced to the maximum term on each, those sentences will be ordered to be served consecutively, which means that if you add 36 months up twice instead of 2 months or 6 years, maximum fine would be $20,000, maximum mandatory fine would be $10,000. You understand that?
Yes, sir.
Other than these charges, Mr. Green, are you facing any other felony charges in any other jurisdiction?
Yes, sir.
Are you currently under community control, parole, post-release control, or community control or probation for a felony in any other jurisdiction?
Yes, sir.
Right now, under the law, if you are convicted of these offenses and serve a prison term, upon completion of the prison term, possible, if the doctoral authority will decide to place you under post-release control for a period of up to 2 years. They don't have to, but they can. The judge is involved with that. They decide to do that, you'll be supervised by a parole officer in the terms that the parole authority sets. If during the period of time that you're being supervised, they determine that you have failed to comply with any of their conditions, then they have the right to return you to prison because you served the entire term for the judge for an additional period of up to 9 months for any one violation, although there is a cap or limit, a cap of whatever term was imposed by the judge. However, if you committed a felony on a post-release control supervision, then in addition to whatever sentence the judge in the new case can impose upon you, that judge could also sentence you for committing that offense while under post-release control supervision in this case to an additional period of 1 year, whatever time is left on that period of post-release control, whichever is greater, that occurs, that must be served consecutively with sentence again in this case. You understand that?
Yes, sir.
Right now, like I said, I'm not mandatorily required to sentence you to prison for this offense, although it's these offenses, although it's known. So legally, I could instead of sentence you to prison, whichever was called community control or probation. That means instead of going to prison, you'll be supervised by a parole officer, probation officer, a term set by this court for a period of up to 5 years. If during that period of time, the probation department felt that you were non-compliant, they could return you. They could file a notice at the court and serve a copy upon you. Then you would have a hearing, and you would be entitled to have an attorney at that hearing. And then the outcome of that hearing was that you failed to comply. And at that time, the court could revoke community control and then sent you to prison for 72 months and fine you $20,000. You understand that?
Yes, sir.
Right, so the charge in count 1 is amended. It reads that on or about May 5, 2021 in Huntington County, Ohio, you did knowingly sell or offer sell methamphetamine and Schedule 2 controlled substance amount equal to or exceeding bulk amount plus 5 times bulk amount in the vicinity of the school, which is now deleted, so that would not be in there. Violation section 2925.0381. And in count 3 alleges that you did the same thing. Count 5, I'm sorry. Count 5 alleges that you did the same thing on or about June 3, 2021. Otherwise, reads the same. Both of those are third-degree felonies. Now, Mr. Green, you understand what it is you've been charged with in those amending count 1 and count 5?
Yes, sir.
All right. And have you discussed the nature of those charges, the evidence in the case, possible legal issues in the case, possible defenses you try to raise at trial, and possible outcome of the trial with your attorney?
And we went through all this yesterday. Are you satisfied with our discussion and going over it?
Okay. So you are satisfied with his advice and confidence in this matter? Are you under the influence of any type of drugs or alcohol at this time?
Been very out for like a month now.
Just answer the question.
Okay.
Get there.
But you're not taking any drugs now? Are you on any prescription drugs? Okay. Have any threats been made that you plead guilty today? Any threats been made that you plead guilty? All right. Now, on page 2, there are several lines that are printed in bold and underlined, and I'm going to read those now. Defendant shall enter a plea of guilty to amend count 1 and count 5. State will dismiss the remaining counts State defense jointly recommend 18 months on each count. No objection to judicial release treatment after 6 months. Defendant agrees to pay back my money in the amount of $420 to the task force. Consideration of plea agreement. Defendant shall cooperate fully with the task force. Now, is that your understanding of the agreement? Have any promises been made to you other than that to get you to plead guilty here today? Now, under the law, Mr. Green, the matter of sentence is up to the judge, not the parties. So even though there's an agreement that the sentence ought to be 18 months on each count, the court's not required to follow that recommendation. Once you plead guilty, and I've heard all the information submitted, if I decide that the sentence should be something different, I can impose a sentence of anywhere between 9 and 36 months on each count consecutive until 72 months, fine $20,000 and suspend your license for 10 years. You understand that? Now, the same holds true with judicial release. The state would not object to you being released after 6 months, but that's not a promise that you will get it because the judge is the one who makes that decision, not the state. And so, if you file your motion for judicial release, I'll look at it, consider it, and if I decide after I've heard all the information that's presented at that time that judicial release should not be granted, I could deny that and you'd have to serve the entire sentence as imposed. You understand that?
Yes, sir.
All right. Now, do you hold any license or certificate from any state governmental agency that regulates any occupation or profession? Now, you have certain constitutional rights you must understand before I can accept the plea of guilty. First, Mr. Wagner was appointed to represent you because you were unable to employ your own counsel. I didn't appoint him simply to work the case out, but to provide any defense that might be available to you under the law that you would like him to provide. So, if you decide that you do not want to plead guilty, that you want to defend against this these charges, and have a trial, and he'll continue to represent you and do that. You understand that?
Yes, sir.
Right now, under the Constitution, Mr. Green, you have a right to have a jury trial on these charges in which 12 people will be selected from a group of citizens of Highland County that are summoned for jury duty on your trial. After they are selected, the evidence will be presented, and then that jury will, and then be instructed on the law, and then that jury will have to decide by unanimous verdict, all 12 of them have to agree, as to whether the state proves your guilt of the charge by proof beyond reasonable doubt, that is either the charge. And again, that verdict would have to be, as to each count, unanimous, meaning all 12 of the jurors would have to agree as to that verdict. Now, if you didn't want to have a jury trial, but you didn't want to plead guilty, you can waive the right, which means you give up the right to have a jury trial. In that case, you would have what's called a court or bench trial, which means that the judge is the one who will hear the evidence instead of the jury. The judge will apply the law, the judge will decide whether or not the state proved guilty of either or both charges. You understand that? Do you speak up?
Yes, sir.
Okay, thank you. Now, under the Constitution, Mr. Green, you have a right to confront witnesses against you and cross-examine them through your attorney. What that means is that the witnesses against you have to come into court and testify in front of you and your attorney and anyone else is present. After the prosecutor is asking questions, your attorney has asked questions. That's called cross-examination. And the purpose of that is to try to bring out evidence to help your side of the case. Do you understand that?
Yes, sir.
The Constitution, Mr. Green, you have a right to use the power of the court to compel or force witnesses to come to court and testify for you, just like the state. So, if you have witnesses you're not certain going to commit voluntarily, your request court issues a court order called subpoena, and that forces those witnesses to come to court and be able to testify for you if you want them to, even though they don't want to be here, which is the same way the state's witnesses are forced to come to court and testify against you. Do you understand that?
Yes, sir.
Now, under the Constitution, you have a privilege of self-incrimination in this case. That means you cannot be forced to give evidence in this trial, or in this case, at any time, including the trial. No one can ever make you testify. The prosecutor can't, the judge can't, you decide. If you decide not to testify, then the fact that you did not testify will be used against you in any way by any person at any time, and no one's even allowed to comment about it except in one situation. If you decide not to testify in a jury trial. and the judge does instruct that jury that because that is your right, they cannot consider it for any purpose. You understand that?
Yes.
Right now, under the Constitution, you're presumed innocent until proven guilty by the state of Ohio on every essential element of the offenses charged in these two counts. What that means is that the burden of proof is on you to try to prove you're not guilty because simply because you've been accused. Back under the law, you don't have to present any evidence in your defense. You may, but you're not required to. But whether you do or not, the burden of proof will remain on the state of Ohio to prove your guilt on both charges on every essential element of those offenses by proof beyond a reasonable doubt, which is the highest burden of proof that's known under the law. You understand that?
Yes.
Now, originally entered plea not guilty, Mr. Green. He denied the allegation in the indictment, denied you committed the crime, and an exercise or invoke all the rights that I just described. Now, if you change your plea from not guilty to guilty, that is plead off to not guilty. If the guilty plea admits the allegations in the indictment, admits their crime, but you committed that crime. And that plea waives up all the rights that I just described for you, except the right to have an attorney. You always have a right to have an attorney no matter what you plead. That exception, your plea of guilty, waives up your right to a jury or a court trial, and waives up the right to confront witnesses issued and cross-examine through your attorney, waives up the right to use the power of the court to compel a court witness to be in court to testify for you, the same as the state, waives up your privilege and self-incrimination because you're saying you're guilty, that's what she finds you guilty, waives up your presumption of innocence because if you say you're guilty, that's what she finds you guilty. Plea of guilty subjects you to being sentenced immediately by a court, and finally, if the plea of guilty waives up a right to file an appeal you think you may have had up until this point in the case for any alleged violations of your rights. Now, if you are sentenced to a maximum sentence or under other circumstances, you have the right to file an appeal. Any appeal would have to file within 30 days of your sentencing and to be filed. You understand all that?
Yes, sir.
And are you a U.S. citizen, Mr. Green?
Yes, sir.
And do you have any questions about the charges or the possible penalties?
No.
You understand them?
Yes, sir.
Any questions about the plea agreement?
No.
You understand it?
Yes, sir.
Do you have any questions about the constitutional rights of your claim?
Yes, sir.
You understand it?
Yes, sir.
Any questions about the plea of guilty, what it means, what the consequences of that will be if you enter here today?
Yes, sir.
You understand?
Yes, sir.
Anything you'd like to speak to your attorney about before we go any further? It's your decision then to withdraw your not guilty plea, plead guilty to the amended first count and count 5 as we just went over in this plea agreement. That is your decision.
Yeah.
All right. Now, as to the reduced amended charge for count 1, that alleges that on or about May 5, 2021, in Hyde County, Ohio, you can knowingly sell or offer methamphetamine, a Schedule 2 controlled substance in an amount equal to or exceeding bulk amount, but less than 5 times the bulk amount. And I'm going to roll through that, strike through that initial one today. Because I was just told by the clerk that word, and this happens, is you receive from the sentence of a missile that says it doesn't match up in the indictment. So I'm not doing that. And I'm going to change the 2 to a 3 up in the title as well. So they get that. So, how do you plead to that charge?
Guilty.
And as to count 5, it alleges that on or about June 3, 2021, Huntington County, Ohio, you did only sell or offer methamphetamine, Schedule 2 controlled substance amount equal to exceeding bulk amount less than 5 times bulk amount provided in Section 2925.31. Same charge as count 1 as it is now listed amended. Third degree felony, same penalties. How do you plead?
Guilty.
Okay. Court finds on this day, in open court, the defendant violated all constitutional rights, made no intelligent voluntary waiver of 11. Please reset the order file, and is found guilty of the charge, amended charge, count 1, aggravated trafficking and methamphetamine, a third degree felony, and count 5, also aggravated trafficking and methamphetamine, a third degree felony. Now, remaining counts are dismissed. All right, as much as there's agreed recommendation, no request for presented to the court, what will be the proceeding sentencing? Anything from the state?
Only one contained the plea agreement, Your Honor.
Good. Anything from the defense?
Yes, sir, Your Honor. We'll ask for the following recommendation of the party. What I'm about to say, Your Honor, is more for the benefit of Alan, just to reiterate what I think is on the line. We did have a discussion in my office yesterday. He's doing great, Your Honor. When I first saw him out of the jail to now is complete 180-degree turnaround. He feels good now. He seems clearer headed. His appearance is night and day. He's been out the Massey house for about 45 days, give or take. I know he's going to FRS on a daily basis. That's how I get a hold of him. I call down there, they pull him out of session. He's been in my office whenever I need him. He calls me whenever I need him. Just the only thing, again, for his benefit that I hate, and I hope he can succeed in this, is, these incidents occurred almost exactly 1 year to the date. I'm not going to lie to the court or even pretend that it may have happened that he did this and cleaned himself up. Since he's gotten caught, he's turned himself around, at least as we sit here today. He's taking this serious. And I understand, we went over this yesterday, true attitudes, you have 3, looking at 19 years before wanting to play with him for years and run him. Hopefully he takes advantage of the offer of the state. They have some faith in him. Granted, no one wants to go to prison, and that's my fear. I've never been, hopefully I never go, but you hear people that come back saying there's drugs all in there. I pray to God, Alan doesn't fall back into that abyss and backslide. Again, we've talked at length with this. Kind of funny, he's seeing the severity of the situation. When I asked him how old he was, he said, I'm 50-year-old, too old for this. So he gets it, Your Honor. Hopefully he takes it seriously, and the court will consider the judicial release in 6 months, and he jumps right back to the Massey house. Adam from FRS and Massey has come with him every time. Seems like those two have a great bond. He's always spoken very highly about him. Your Honor, I guess we just asked the court to follow the recommendation. I do have 2 questions after the court does sentencing, Your Honor. If I can either ask them now or later, it doesn't matter. So. One, I was very careful on Rule 16. I did call Ms. Collins, let Alan view the video in my office yesterday. It was not recorded. He has requested a copy of his discovery. We've gone over it in detail. Am I allowed to release that? You know who the CI was, so nothing else incriminating. Am I allowed to give him a copy of that today so he can have for his record?
The materials are counsel only, Mark?
I think the video was
You can release anything that's not Mark counsel only.
I think the video was released, so it's not right.
What's going to see what, Mark?
It just says CI 12.
Yeah, anything that's not Mark counsel only, the state would have no.
Yeah,
Okay.
I'll do anything that's not Mark counsel only.
I'll release that today. And then he's made the request, and I said, Alan, I'm not going to do it. I made the exception for him, because I know this court doesn't. He has asked to consider the court to allow him to report Monday morning at 8. I guess he earned his first weekend pass, or a weekend pass for Massey. He came here today with his family. I would advise him, if the court granted it, he doesn't show up, consider the deal gone, and we might have an escape or a failure to appear, or it could get worse. That's where we're at, Your Honor. Again, I just reiterate for Alan, I hope he does well. It's been 1 year since this happened. If you get in prison, please walk the line.
All right, Mr. Green, anything you would like to say?
It's gonna be good.
All right, it's the order of judgment court that should be in our hereby sentence on count 1 and count 5, each to a term of 18 months incarceration, rehabilitation and correction. Those sentences will be served consecutively in one after another for 6 months. The court closes those because these offenses were committed as part of one more series of conduct, and one single prison term not accurate reflecting the seriousness of the offenses caused, and the sentence being proposed not disproportionate to the harm caused. Further, the sentences are stipulated. Now, you're entitled to jail time credit of 16 days. upon completion of that sentence, if you serve the entire prison term, the adult parole authority may, at their option, pursue post-release control for a period of up to 2 years. They don't have to, but it's strictly up to them. Court's not involved in that. If they do that, you'll be supervised in the terms that they set. If they determine that you fail to comply, they can return you to prison, may serve an additional period of up to 9 months for any single violation up to a maximum half or whatever the prison term. In this case, is 18 months. If you got 36 months, so half that 18 months will be capped. However, if you've been in the felony while under post-release control supervision, then an additional ever sentence judge in the case could impose a fine. That judge could also impose an additional sentence for committing that to offense while under post-release control, in this case, 1 year or whatever time left on that 3 years post-release control, whichever is greater. If that occurs, that must be served consecutively with the sentence again in the case. You're also ordered to pay the court costs, the judge grant execution order, and if you fail to pay that, then the court can collect that directly into the federal bank account with the authority for the assets you have. That doesn't collect it, then on completion, because you're not longer in prison. The court permits you to do service, give you credit, keep your work in an hourly rate, set up for keep your work, reduce your judgment by that amount. You're also ordered to pay restitution to the County Task Force in the amount of $420. And that's paid through the victim with the escrow account, and you're required to pay any fees that are associated with that. And that is a substantive sentence, so it doesn't go away even if you serve your entire prison term. It can be enforced separately, and if you fail to pay it, you can be brought back to court for that. Been any change in financial circumstances since I appointed Mr. Wagner? Right, the court will find that you do not have the present means to pay any mandatory fine more than you might in the future, and therefore the mandatory fine is waived. There will be no license suspension imposed now. And of course, when orders of consent to be executed forthwith, though you've been in treatment since you were charged, and that's a good thing. But history teaches us that the biggest danger that people within a residential treatment have is the first pass home. And then once they get out, go back in the community, it's extremely dangerous time for them. And so, in order to make sure you don't go out and do something relapse, even though I'm sure you don't want to, just tell you it happens a lot. And if that ever happened, just make things much worse for you than be guaranteed you would get. Is right now, open. So, of course, when you're going to be taken into custody and remain in custody. Sure. Anything further from counsel?
Hang on, sir.
Thank you.
Okay. I put on my calendar, 6 months from today, I'm possibly in Georgia.
Hey, John, did you also file a 169 case?
No. Oh, did you ask me? No, because it's not connected to our drug court. It's not drug court. No. Yeah, we were wondering why it wasn't actually added to it all. Like,
Yeah, hold on, let me give you.
when we did it, but
Hey, you want to call
he had
the
one
office?
time wanted to do that case, but denied it way back.
Just call my office.
He's still being supervised.
Right. I mean, he's being supervised, but when we filed it, we only filed it for the drug court case.
Right. I don't know why that is.
Can we connect them still?
He was sentenced on that. That one, I'm going to go ahead and put him in that one.
That'd help. We get his old one.
17.
Right, yeah.
Hey, John. I'm only looking for you can't find Barbara, just go to the Magic Tunnel. It looks like a car wash.
Oh, I know.
I see him about 3 times a week.
No, that's not the point.
Huh? Yeah.
The bad thing about that is,
I come around my corner of the truck and they went right in the office.
and the funny about the, when you didn't shut the report, I just saw the front of him, hey, come in here and report.
That's how I
Hey,
get.
Virginia, I just found out, I don't know how this happened, I guess we'll have to blame it on the drug. Oh, yeah, she's over there. 20 CR 169, for some reason, he's not drug. And so I'm gonna go ahead and, I'm gonna continue, there's no good sanction here.
That's what transition housing.
I'm going to add that one. Should have been admitted to that one as well, so I'll go ahead and make sure he's agreeing.
Yes, sir.
But we're gonna transfer it over to that.
Yes, sir.
Yeah.
Yeah,
Why
it
did
was,
you do that? already made a commission, I guess, that you had used it after you came in on Monday. So, I think you corrected that, did that. Is there anything you want to say, Mr. Wagner, or you want to say, Mr. Burke?
Yeah, if I may.
To be honest, sir, but saying that point, that's sort
I just got with man, lost my focus for a second, and I'm still working, trying to move forward, learn from my mistakes. I apologize.
Okay. Let's see, for a, this is first, test.
So, first violation, yes.
Okay. But, and they had any previous, sanction for, positive test?
I don't think so, no.
All right, well, Mr. Barger, you know, you did run, I'll give you that, but it wasn't very smart, what you did. And you want to give me any explanations why you didn't show up before Friday?
I don't have any good ones, sir.
Okay. Just didn't want to face the music, I guess, huh? Or, what's your work schedule?
7:30 to 3, Monday, Wednesday, Thursday, Friday, and Saturday, and Tuesday and Sunday is, Tuesday is 2 closed, and,
Tuesday what?
Tuesday is 2 closed.
2 to 8.
Yeah, 2 to 8, 2 to 8.
2 to 8 on Tuesdays.
Tuesday, and what about Sunday?
Friday and Sunday is my days off.
Friday and Sunday. Okay. Well, the court's continuing you on, community control and drug court, those cases. You'll be required to do community service of, what is it usually,
I think we were going to have 20.
all right, 20 hours of community service. Within 5 days. And you work tomorrow, 2 days,
No, 7:30 to 3.
10:30 to 3.
Yeah.
All right. Sunday, you work 2 days.
Tuesday's the only day I work, today.
Okay, what day do you work Sunday?
No.
You're off?
Yeah.
All right. And you are going to be required to serve 2 days in county jail. You report to jail at what time do you get off tomorrow, 3:30? Huh?
Yes, sir.
You report to jail at 5 p.m. and you'll be released Sunday at 9 p.m. And that way you won't miss work. And all the other, again, all the other conditions pretty sure need to apply. All right. Any questions?
No, sir.
All right, thank you.
Thank you, Your Honor. Good luck.
All right, are you, Jesse Milton Vinegar? All right, this is case number 22 CR 40, Dave Line versus Jesse Milton Vinegar. This hearing is being conducted by Zoom. He's appearing from the jail. He's appearing Daniel Witt, appearing from her office, appearing from the prosecutor's office, Prosecutor King. This matter is set for a plea. Now, Ms. Witt, you and your client both agree to have the hearing conducted remotely rather than as a personal occurrence in the courtroom.
Yes, sir.
Do you agree with that, Mr. Vinegar? Right, the agreement is a 3-page document, Mr. Vinegar. I'll hold this up as your name, case number, plea of guilty to count 1. I'll hold that up to the camera. Right, do you see that there that has your name and the plea of guilty? All right, on page 3, there are signature lines, and there's a sentence about not quite halfway down. It says, I enter this plea voluntarily, and right below that, there's a signature that appears to be Jesse Vinegar. To me, is that your signature next to my finger? All right, and before you signed it, did your attorney go over it with you and explain everything to you? And you understood when you signed it that it's an agreement to plead guilty, which means there's not going to be a trial. And the next step would be a sentencing hearing. And you think that you had enough time to fully consider this matter before making the decision? I know you're Wednesday, you've been there a couple of days, so you had enough time? Okay. You're not rushed, you weren't rushed or pressured into doing this? You're entering into the agreement and signed it voluntarily? All right, now the agreement states that you're going to plead guilty to count 1, which is aggravated trafficking and methamphetamine in the vicinity of school zone under 2925.0381, a third-degree felony. And further states that you understand that the maximum prison term for that could be 36 months. Minimum would be 9 months, and there are different levels in between those two ranges. It goes 9, 12, and every 6 months up to 36 months. There's a fine available of $10,000, mandatory fine of $5,000, and a license suspension is possible 6 months to 5 years. There's a prison term that's not mandatory, but it's presumed. Yes, sir.
Yeah, it's mandatory.
Oh, okay. It is mandatory. Oh, okay, I got you, that's right, because of that allegation, yeah, that's right. Okay, so that means that there's no possible early release or community control. You understand that?
Yes, sir.
Okay. Now, under the law, once you serve the prison term imposed by the court in this case, it is optional that you put under post-release control by the adult parole board. So they'll make that decision, and if they do, it would be for up to 2 years under the terms that they set. And if during that period of time, they decide that you have failed to comply, they can return you to prison even though you served the entire term set by the court for an additional period of up to 9 months for one violation at the maximum, or half of whatever prison term is imposed for all violations. But if you committed a felony while under post-release control, then in addition to whatever sentence the judge in the new case can impose upon you, that judge can also sentence you to an additional term of 1 year, whatever time is left on the post-release control period, for committing that new offense while under post-release control in this case, and that would have to be served consecutively the sentence of the new case. You understand that? All right, now, so as is indicated, there's no possibility of community control or probation for this offense because of prior convictions. You understand that?
Yes, sir.
Now, the charge alleges that on or about May 11, 2021, in this county, you knowingly sold or offered to sell methamphetamine instead of 2 controlled substances in the vicinity of the school zone. The defendant having been previously convicted of 2 felony drug abuse offenses, trafficking of drugs in 9 County Companies Court case number 10 CR 0058 on May 5, 2010, and aggravated possession of drugs in the County Companies Court case number 20 CR 0076 August 21, 2020. In violation of section 2925.0381. So that's the third-degree felony with penalty of felony. Now, do you understand what it is you've been charged with, what the state said you did, when or how they let you did, Mr. Baker? Have you discussed the nature of the charge, the evidence in the case, possible legal issues in the case, possible defense you can try to raise the trial, and possible outcomes of the trial with your attorney?
Yeah.
And are you satisfied with your advice and confidence in this matter? Are you under the influence of any type of drugs or alcohol at this time? Has anyone threatened you to make you plead guilty here today? Now, toward the bottom of page 2, there's 4 lines printed in bold and underlined, and then there's a couple of one of those things that's scratched out the number, and so I'll read it as it's written now with that change. Defense shall enter plea guilty to count 1, state will dismiss count 2, state defense jointly recommend 12 months mandatory incarceration, second to the term of incarceration defense currently serving, case number 20 CR 76. Defendant agrees to repay bond money to the Huntington County Tax Force amount of $65. And the 18th are marked out with 12, but over to the left, I see Mr. Wood's initials and Mr. King here agreeing with this.
Yes, sir.
Is that your understanding of the agreement, Mr. Vinegar?
Yes, sir.
Does anyone promise anything other than that in case you plead guilty here today? Now, under the law, Mr. Vinegar, the matter sentence is up to the judge, not the parties. So if you plead guilty, I'm not required to follow that recommendation. I could decide that you should have a sentence greater than that, up to 36 months if, in the increments that are permitted by law. But I decide that's the appropriate sentence. You understand that?
Yes, sir.
All right, now, do you hold any license or certification from the state of Ohio for any type of occupation or profession?
No, I'm looking for it right now.
Okay. Yeah, that's a trade certification, there's not a license required, so okay, good. Good. All right, now, you have constitutional rights you have to understand, or you have to plea. First, you have the right to have counsel, and Ms. Whitman appointed to represent you. Now, her appointment wasn't simply to work the case out, but to provide any defense that could be provided to you in the law she would like her to provide. So, you decide that you don't want to do this, and you rather defend against this charge. And she'll continue to represent you and defend the case, including a trial, if that's what you want. You understand that?
Yes, sir.
Right, under the Constitution, you have the right to have a jury trial in this matter, which 12 people will be selected from a group of citizens in Adher County that are summoned for jury duty on your trial. After those 12 are selected, the evidence will be presented, they will be instructed on the law, and then that jury of 12 will have to decide by unanimous verdict, meaning all 12 will have to agree whether the state proved your guilt. Now, if you didn't want to have a jury trial, but you didn't want to plead guilty, you can waive the right, which means you give up your right to have a jury trial, and in that case, you have called a court bench trial, meaning that instead of the jury hearing the evidence, it would be a judge hearing the evidence. The judge will apply the law, and the judge will decide whether or not the state proved your guilt by proof beyond reasonable doubt. You understand that?
Yes, sir.
Under the Constitution, you have a right to confront witnesses against you and cross-examine them through your attorney. What that means is that the witnesses against you have to come in court and testify in front of you, your attorney, and anyone else is present. After the prosecutor's done asking questions, your attorney asks questions, that's called cross-examination. The purpose of that is to bring out evidence and help your side of the case. You understand that?
Yes, sir.
Right, under the Constitution, you have the right to use the power of this court, compel or force come in court to testify for you, just like the state. So if you have witnesses you're not certain going to come in voluntarily, you request or issue a court order that's a subpoena, and have to force those witnesses to come to court to be able to testify if you want them to, even though they didn't want to be here. This is the same way the state's witnesses are required to come to court to testify against you. You understand that?
Yes, sir.
Under the Constitution of Vinegar, you have a privilege against self-incrimination, which means you can only force the evidence in this case or testify at any time, including trial. So no one can ever make you testify. Prosecutor can, judge can, issue a decision. If you decide not to testify, the fact that you did not testify, not be used against you in any way by any person, no one's even allowed to comment about it. One exception to that is if there's a jury trial, you did not testify. The judge instructs the jury that because that is your right, you cannot consider it for any purpose. You understand that? Excuse me. Now, under the Constitution, you're presumed innocent. Excuse me. We have a wrong pipe. All right. Under the Constitution, you're presumed innocent of this charge until proven guilty by the state of Ohio at every essential element of the offense by proof beyond reasonable doubt. What that means is that the burden of proof isn't on you to try to show you're not guilty of the charge simply because you've been accused. In fact, under the law, you're not required to present any defense at all at your trial. You may, but you're not required to. If you present any evidence of defense or not, the burden of proof remains upon the state of Ohio to prove your guilt of every essential element of the defense charge. again, by proof beyond reasonable doubt, which is the highest burden of proof established under the law. You understand that? All right, he originally entered a plea of not guilty. That charge denied the allegations in the first count, denied you committed a crime, and then exercised or revoked all rights I just described. If you change your plea, not guilty to guilty, that is the complete opposite of not guilty. Guilty plea admits the allegations of the indictment, admits their crime that you committed that crime in count one. And that plea waives and gives up all the rights that I just described for you today, except your right to have an attorney. You always have a right to have an attorney, no matter what you plead. But with that exception, your plea of guilty, waives gives up the right to a jury or court trial. Waives gives up the right to confront witnesses against you and to cross-examine them through your attorney. Waives gives up the right to use the power of the court, you can compel or force witnesses being forced to testify for you, the same state. Waives gives up your privilege of self-determination because you're the one saying you're guilty, that's what you find you're guilty. The waives gives up your presumption of innocence because if you say you're guilty, the state doesn't have to prove you're guilty. It also subjects you to being sentenced immediately by the court, which is what is proposed here. And finally, it waives gives up any right to file an appeal that you think you may have had up to this point in the case. Now, if I sentence you the maximum sentence or under certain circumstances, you file an appeal, that appeal would have to be filed within 30 days for sentencing entry to be filed. You understand all that? Are you a U.S. citizen, Mr. Baker? Now, one thing I think I kind of got sidetracked is as to this plea, since you're already serving another sentence, it's in the plea agreement, you understand? Any sentence that will be imposed here will most likely be ordered to be served second of your current sentence. Okay. All right. Now, do you have any questions about the charge and possible penalty? You understand? All right. Have any questions about the plea agreement? You understand that? Have any questions about the plea of guilty, what it means, what will happen if you hear that plea here today? Do you understand the plea of guilty, what it means, and what the consequences of that plea? Is there anything you'd like to speak to your attorney about before we go any further? If you do, I can put you in a break right now. Do you have any questions at all, Mr. Manager, about anything that we've gone over here this morning? Then is it your decision to withdraw your not guilty plea, plead guilty to charge in count one, pursuant to the terms of the agreement that we've just done? All right, then as to the charge, which alleges that on or about May 11, 2021, Miami County, Ohio, you did knowingly sell or offer to sell methamphetamine, in the case of 2 controlled substances in the vicinity of the school zone. Defendant had previously been convicted of 2 felony drug abuse offenses related to trafficking drugs in Miami County Common Police Court case 10CR 0058 on May 5, 2010, and aggravated possession of drugs in Miami County Common Police Court case 20CR 0076 August 21, 2020, violation of section 2925.03A1 Idaho Code. The third degree felony carrying mandatory prison term between 9 and 36 months being provided by law. A fine of up to $10,000, mandatory fine of $5,000, and a loss of license suspension of 6 months to 5 years as included. Alright, thank you. Court finds on this day of the court, the defendant was advised of all his constitutional rights, making no intelligent voluntary waiver of the same, since criminal 11. Plea is accepted for file. And found guilty of the charge set forth in count 1. Count 2 is dismissed. Alright, the court will go ahead and proceed with sentencing forthwith. Anything further to say?
Motion to continue the plea agreement.
Alright, Mr. Whit, you have anything like that?
Yes, Your Honor, just as the first call is for recommendations, so that the additional time is appropriate, you can use time first rate as to it, and returns back in society that can still think of her time to not follow that at the same time.
Alright, Mr. Vinegar, anything you'd like to say? How old are you, Mr. Vinegar? How many numbers have you got now?
This is my fifth one.
Okay. Had a lot of your adult life in prison, so, I think you have the ability to, do something with yourself. And, getting a trade like welding is a good trade, and so, there's a demand for people with that skill, so hopefully, like you said, you'll decide to complete that and use that when you get out. So, based upon, everything that's been stated, the court, agrees with the plea agreement, and therefore the order of the court that the defendant be sentenced to a term of 12 months mandatory incarceration, which should be required to serve consecutively to the sentence that is currently served in this case number 2776. According to the sheriff, jail time credits been while you've been out from prison, so that's 2 days, and then they'll give you an additional credit once you return to the institution. And upon completion of this prison term, it is possible the all authority may choose to put you on post-release control supervision for a period of up to 2 years. They don't have to, but it's up to them if they do. You'll be supervised on the terms they set, and during that period of time they determine that you failed to comply. They can return you to prison to make a certain additional period of up to 6 months for one violation or a combination violation. That's also the cap, since that's 1/2 the term. However, if you've been in felony or in post-release control supervision, then the judge in that new case is authorized and sentence you for committing that offense while under post-release control, in this case, for an additional period of 1 year, or whatever time was left on the period of post-release control, whichever is greater. That occurs as you serve consecutively sentence in the case. You're also ordered to pay restitution, the amount of $60 to the Lyon County Drug Task Force, which is a substantive sentence that remains after you serve all your prison term to be enforced through future legal proceedings. You're also ordered to pay court costs, which doesn't grant excuse in order to fail to do that. And the court clerk, things like that, the various things include that on bank accounts, legal services, and other assets you may have. If that doesn't complete it, then it doesn't get done, then the court will be serviced once you serve your prison term in this county. And give you credit for each hour you work in an honorary except for the court. Each hour you work, reduce your credit by that amount to pay for. Court finds that since you're incarcerated will be for a significantly long period of time, there's no likelihood you're able to pay the mandatory fine in the future, so that will be waived. There will be no license suspension of proposed item. All right, is there anything further, counsel?
Yes, Your Honor, wasn't addressing whether this sentence would be consecutive.
Oh, it was ordered to be consecutive. I didn't say the reasons. The court will find that this offense was committed as a different course of conduct in the other cases, and that the defendant's criminal history demonstrates that it's necessary to protect the public from future crime. It also stipulated the sentence and the harm caused by the multiple offenses not be adequately reflected by one single prison term, and the sentences being imposed are not disproportionate to the harm in view of the offenses, since this is a low sentence. Okay, anything further?